listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, welcome to this episode of Let's Get Surety. This is Kat Shamapande, your host. And today with me, I have my co-host and NASBP CEO, Mark McCallum.
Hi, Kat. I'm glad we're addressing this important topic today.
Yeah, we're going to be talking about commercial surety account bankruptcies. With COVID and the COVID pandemic going on, I know we've all seen a lot of companies in the news that are failing amid this shutdown. So I think it's a really important topic to talk about. And to discuss that with us today, we have Chad Schexnayder, and he's a partner at Jennings, Haug Cunningham. Hey, Chad.
Hi.
Thanks for joining us. It's great to have someone with some background and information in this bankruptcy field to talk to us about this.
Well, we're certainly very busy with that right now. So this is a very a good topic.
So before we dive into the whole thing, with bankruptcy, are there some things that you would see before the actual bankruptcy filing takes place? Is there something, red flags that people should be looking for?
Sure. I think there are. And, the fact of the matter is that the, financial distress of a commercial account is often not a complete surprise to the surety. And, recently we hear about what's going to happen before it happens. I mean, it's not like we didn't know that Pier 1 was going to file. We didn't know that Hertz was going to file. And we've been hearing JCPenney was going to file for years. Everybody, whether it's Neiman Marcus or Chuck E. Cheese, or all the oil and gas cases that are happening because of the COVID effects on prices.
Yeah.
Often the sureties are aware that this is coming. And, it's not like we just hear about it for the first time when it shows up in, the Wall Street Journal. And so a lot of times the surety is thinking about what they can do to improve their position, knowing that a bankruptcy may be coming or that the company is clearly struggling. And the first thing they think of course, is taking or improving a collateral position. And, that could be cash. We'd all love cash. But it could be a deposit into some pre-existing escrow, or it can be a letter of credit. That's a popular way to do that. And one of the problems of planning just before things go badly is, let's assume the surety does in fact make a request. The company needs surety credit, of course, so it says fine and hands the surety $10 million in collateral, which is whatever, 20% or 50% of exposure. And then within 60 days, the company files bankruptcy. One of the big concerns we're running into now is that in bankruptcy law, there is a doctrine that allows a bankruptcy case or a debtor to actually go back and reclaim payments that it made in the 90 days prior to bankruptcy. So sureties are having to address this dilemma of, well, we need to ask for and receive collateral, but we are under a real substantial risk that we may get it, but somebody may show up at our doorstep in 6 months or a year and say, yeah, I want that $10 million back.
Are there certain things that the surety can do in an effort to avoid that clawback?
There is some things they can do. Of course, even if the clawback is a risk, it's kind of the bird in the hand, two in the bush, possession's 9/10 of the law, make up your favorite, saying for it. But right. We always want to take the money. Worst thing that happens, you got to give it back. So, right. But, some forms of collateral are better. I mean, a letter of credit is different than cash because of something called the independence principle, which basically says that the money that the surety receives from a letter of credit draw is not the debtor's money, it's the bank's money. And so it sidesteps this concept of a preference doctrine where the debtor could recoup its money that was used to pay a creditor in the 90 days. Well, under the independence principle, letter of credit proceeds are not its money. They're viewed in the court as the bank's money. Now, that's not an ironclad perfect guarantee because depending on what transactions the debtor engaged in to get the letter of credit, may still be some exposure for the surety's collateral, but that's an example of a collateral form and a step they could take that's clearly superior. The one other thing I would say is it's important to document the why. It will matter later that the surety, for example, agreed to continue providing surety credit to this nearly bankrupt company. And I don't mean writing a new $50 million bond, but, many commercial bonds are cancelable, require continuation certificates or renewals. And the fact that the surety has allowed that to occur is actually an offset or a defense against this attempt to take back the cash.
Okay. Given what you've just talked about, are you seeing sureties being more proactive in their communications or touching base with their commercial surety accounts right now?
Definitely seeing a lot more of that. Now, there always is a relationship. Commercial accounts, it kind of works that way. Of course, we have the agent who's, often, not always, but often a direct bridge, and there's a fair amount of communication there. These accounts are often more sophisticated about their need for surety credit than at least I used to see in my practice 5 or 10 years ago. Okay. And so often the account will seek to solidify its relationship with a surety or sureties as one of the steps before they go in. In the old days, we were sometimes a bit forgotten until it all hit the fan, but now we're seeing more direct discussion leading up to it, which certainly has improved the position of the surety in the Chapter 11 bankruptcy case.
That's great to hear. You had mentioned a few names. Are you seeing certain trends in commercial accounts in terms of sectors that are perhaps having the most difficulty right now?
Yeah, I think we're certainly seeing an enormous volume of oil and gas cases. So, these plugging and abandonment and operation and permit bonds, which are very large bonds, are required for the kind of drilling and operation things that you see, whether it's, in deep water or in the near shore, in the Gulf, and huge number of bankruptcies. So those, because people stop buying gas, people stop traveling, then, we all know the oil prices fell dramatically. And many of these operations, they can't operate at the prices per barrel that we're seeing now. So that's huge. And used to be that oil and gas cases had a certain profile. They would go in and take this huge amount of debt. They would give a bunch of that debt ownership in the company. They would do a debt for equity swap. And then they would come right back out because it's wells and they pump oil and oil makes money and it was not complicated. The problem we're running into now is many of those companies did that in 2015, 16, or 18, and now they're back and they don't have as much of a plan. Of course, retail, we've all been hearing about it. We're seeing it in big effect now. They were struggling anyway, and then they shut their stores. So we're seeing those are falling, pretty heavily. Some things are surprising us. The car rental industry, this Hertz case is massive in scope. Right. And I don't know that it will be the only one. We're hearing from the owners of movie theaters, which are very big operations. Not only have we not had anybody in to see movies, we'd love to reopen, but Hollywood's not releasing any movies. So what can we don't see a path out of this. And I think really the big thing that's going to happen, it's not going to be as splashy and as large, but all the people who supply all of those other industries, that make the components, that bring things, that do the services, those companies are kind of the next tier. And there's 15 of those for every other entity that files. And I'm believing that we're going to start seeing a lot more bankruptcies from, those companies. They won't be of the same magnitude perhaps, but, there may be thousands and thousands of those. And that's where sureties are going to, feel like it's kind of coming from all directions.
I keep wondering about cruise lines, given
Yeah.
what has occurred, and I know there are certain bonds that they are required to post, federal requirements and other requirements. Are you hearing anything in that sector?
Well, I know one has filed, but I think it's foreign based. I'm trying to remember now. I may get it confused, but so there certainly is some thought that that's true. All kinds of other related travel and tourism industries are clearly going to be affected. I don't know how well the airlines are doing globally. Lord knows the airlines are sophisticated consumers of the Chapter 11 process, I guess would be a nice way to put it. So we're certainly going to see some of those. And each industry, has a different need for commercial surety credit. So a rental car company, as it turns out, uses massive amounts of bonds to secure concession agreements with airports.
Right.
But another industry might only use some utility bonds and some occasional permit bonds. So it's not always, the same, but each of them are going to present some challenges.
So you have used the term Chapter 11, and for the uninitiated like me, could you just kind of quickly tell me what that really means versus like another term like Chapter 7 or something like that?
Sure. In bankruptcy, it comes in a lot of flavors, frankly. There are 12s and 15s. We got all kinds of chapters, most of which really the surety doesn't care about. We're not involved in a lot of family farmer bankruptcies. It happens, but not a lot. But Chapter 11 is really the workhorse of the commercial industry reorganization. So it is by far the most complex form of bankruptcy, and it's where a company typically goes in and attempts to reorganize its affairs. It can be used for a large-scale liquidation. Often Chapter 11s are really a way to take in a company and sell off the component parts and thereby generate some continuing business entities and some return for creditors. An example might be iHeartRadio, which also owns some very valuable advertising in airports and places. And so these companies are separate now. So Chapter 11 can do a lot of things, but it is very, very expensive. And the longer you stay in, the more that additional financial drain weakens the prospects for reorganization. The other cases like Chapter 7, straight liquidation. If you imagine if you walk in and say something catastrophic happened, we've got no way out, we don't know what to do. Here are all of our assets. They're liquidated, monetized, and then fairly distributed amongst the creditor pool. And that's all there is really to it. So what we're typically seeing, we do see some companies that just say, I'm done. But mostly we see these large Chapter 11 cases. And because they're kind of a living being, they keep operating the business, but they do it under court scrutiny. It involves a lot more time and effort for both the company, but also for the creditors to understand what's going to be done, what's the plan. And I'll give you the easiest example. If a company stays in Chapter 11 for 16 months, during that entire time, they are essentially using surety credit.
Yep.
So if they're continuing to keep all of their stores open and the utility bills are, tens of thousands of dollars a month, sureties have written bonds to those utility companies. And if the debtor operates but doesn't succeed or doesn't pay the bills during the case, the surety's exposure, which might have been, $4 million in utility bonds, but in terms of real exposure, might have gone from a few $1,000s in unpaid bills at the time of the bankruptcy to, $1.9 million in unpaid bills 10 months later. So, it's still a relationship. It's still an account. The problem is the surety is somewhat hamstrung in what they can do. Once there's a bankruptcy filed, a Chapter 11 pending, they can't send a collateral demand to the account because of the automatic bankruptcy stay. They can't just cancel the bond and say, I'm not taking this ride anymore. As to prospective liability, I want to give these obligees notice that, we want to cancel these bonds. Well, that can't be done either without going to the court and essentially asking permission. And as you might imagine, where there's this gigantic company and thousands of employees in this bankruptcy case, and a surety shows up and says, yeah, I'd like to cancel all the bonds and effectively put this company out of business, the surety has a real uphill battle to enforce those kinds of rights. It can happen, but obviously it's an ongoing account, but you lose a lot of the ability to control the risk.
So then, given that, and obviously the surety's strong interest in kind of knowing the mindset of the business it's providing support, how much or how well positioned are sureties to know when that decision is going to be made and what kind of decision it will be? Or they pretty much, they know it when it's filed?
Well, yeah, it varies so tremendously. Often they don't have any real ability to understand what's going to happen. And then it ranges all the way to the case where, they're essentially, I don't want to use the term partner, but they're part of the process, and they actually are consulted at the early stages of the case or even before the case about how this ought to work and how it will work better if they take into account the surety's concerns and needs. An example would be a company that's going to sell off a couple divisions and generate money. Well, those divisions also have surety credit. When they're consulted early, a surety is able to suggest to the professionals that are employed by the debtor, if when you put this out for auction for potential purchasers, you put that in your purchase agreement that whoever buys this has a legal obligation to you to go in and replace the bonds and to assure the exoneration of the existing bonds, then you, the account, will be clear of any debt to us. And at the time you put things out for bid, you can put anything in it. Everybody loves it. If you think of that provision after somebody's already the winning bidder and has agreed to pay, $900 million, then it's a struggle. And the people even start arguing over, who should get the collateral back when we do get the bonds exonerated. I bought the company, so shouldn't I get the collateral back? And the surety, if involved early, has seen these problems and knows how they play out and can do a lot to help the process. But sometimes the case is moving forward. Many bankruptcies now, particularly Chapter 11s, because they're so complex and so expensive, the professionals will go out and negotiate basically the terms of the plan with the major constituencies like, the lender and bondholders before the bankruptcies file. And the day they file, they know they have the votes to get the plan approved and confirmed. And those cases are like a barreling freight train. They sometimes only stay in bankruptcy a matter of months, and everything's on short notice. And the surety has got to be quick and nimble to get in there and talk to people and get things, if you will, aligned properly so that they don't do violence to the concept of surety credit. You've got to move crazy fast because this juggernaut is going to roll right over you if you even take as much as a month while you think about what might happen. Right.
So the business has made the decision for reorganization. It is filed. The surety now is on notice of what's going on. Kind of what happens next? I mean, what is the surety thinking then? As you said, they're going to continue with that credit arrangement by necessity. What else is going on?
Well, often right after the filing, particularly in a Chapter 11, it has become the standard procedure to file what they call first day motions, which are pretty much emergency motions that allow the debtor to continue its business operations. They could be, I need permission from the court to make payments to keep my insurance coverages, to, use my existing cash management system, pay any employees who didn't get their paycheck for some of the pre-petition work so they don't all quit, order utilities not to cut off services, a lot of things, borrow money for Chapter 11 operations. I mention that because in the last, I want to say, a little more than 5 years, maybe 5 to 10, one of the motions that's been added to that is the motion to continue my surety bond program. They asked the court on literally days after the bankruptcy is filed, this motion is on for hearing already. And we like the idea that they understand the concept of surety credit. Unfortunately, the motions have gotten watered down to the point where they don't really help the surety as much as we would like. They may say, you can pay premiums for bonds if you want to. But in the early days, they would say things like, and you can, reform your relationship with the surety. You could provide collateral if you need to. They had a lot of great flexibility, and that's what you need to continue that business operation. And, frankly, there's other things in those first day motions that matter a lot to the surety. So, for example, often they have a new lender in bankruptcy, and then they just put in blanket language that says, the new lender gets a lien on every asset we own. Well, one of the assets the debtor owns is the $5 million in cash that's held by the surety. We hold it as security, but it's not the surety's money. And so you've got to watch for those things and make sure they get reformed so that they make it clear they're not claiming a lien in the collateral the surety's holding. We love the motions that say the debtor can pay vendors like taxing authorities, utilities, workers' compensation claimants, customs duties, because those are all things that if the debtor doesn't pay them, a surety may have to. So after that initial stage where you've got all these motions that you kind of need to see what they do or don't do to the relationship, during the case is where the debtor continues to operate, is sometimes making the situation not always better, for the surety by, doing things like running up bills that are covered by bonds that, they may not be able to pay. And, that's kind of where the dilemma is. If the company successfully reorganizes, most of the time with some modifications to plan language, the surety can kind of move through and continue as a credit provider. Or if they choose, get out and somebody else might move in. If there's a stumble, if the company doesn't make it, if they get crossways with the wrong creditor constituency and the whole thing explodes, that's where it's most dangerous for the surety, because people will have been building up claims that will then show up as to the bond because the debtor is going to be going out of business or liquidating somehow. And we have to keep, a real close eye on that type of stuff. And not just be complacent that this company has been in business for 100 years and they're really large. So I'm sure this will all work out okay.
Right. So it sounds like there has to be a lot of education that is done. And can the surety really be in a position to do that adequately? And it sounds like you have to be very proactive about what's in those motions. Are there other strategies at play to get that education across?
Well, it's interesting because, often the surety can't demand things,
right,
but the agent can be a real useful tool or an ally in this process, because while the surety can't send out a notice and say, hey, I'm getting uncomfortable, it doesn't look like you're paying these utility bills current, and I would like to have $5 million in collateral, give it to me. That's a stay violation. But if you go to the agent and say, hey, look, we're not going to authorize any more renewals, no continuation certificates from here on out, because the surety is not obligated to do any of that. And we're thinking, we're just talking still, but we're thinking about potentially asking the court for stay relief to start canceling these bonds because the debtor is, essentially incurring liability on our credit and, we're unsecured. And the agent who's looking at all the relationships goes to the debtor and says, look, if you want to keep your surety credit line, you're going to either need to change the way you do business and start paying these claims, or you're going to need to, partially secure the surety during this cash flow bump you're having that you think you'll be recovered from in 4 more months. And that's just a business discussion. That's not a demand. That's not a threat. Right. And it's nice to have somebody that the account has worked with for years and trusts to help them with everything from, the insurance to surety credit to all these other things, who understands and can explain to the debtor in a non-threatening way why they need to address these, concerns from the surety. And the surety needs to speak sometimes to the bankruptcy counsel. Some of the debtor has, because some of the scariest things aren't intentional. These plans can be 200 pages long, right, and very sophisticated. You can imagine the financing structures. And so they use templates, and the templates say things like, any claim against the debtor that existed before the confirmation, that's when the plan's approved, are all gone. And any liens in any property are all gone. And they do that to catch what they don't know about. They don't intend to dispossess the surety or destroy the credit relationship. And if you communicate with them and say, I need you to put language in the plan that says, by the way, however, we're not changing our relationship, with our surety, and we reaffirm our indemnity obligations and the collateral agreement that we signed. And when we form a new company, very common, right? They form a new company in bankruptcy legally, and it continues as the surviving entity, possibly with new ownership of creditors and stuff. That new entity will also execute indemnity agreements in favor of the surety for ongoing operations. You don't tend to get a ton of resistance. It's just they weren't thinking about it when they drafted it. And if the surety doesn't get that language put in, somebody else could take advantage of it adversely to the surety later.
Right. Well, I mean, I guess if you're looking at it, from a 50,000 foot perspective, at the end of the day, they want to emerge. They want to be reorganized, be an ongoing business. Preserving that good surety relationship, I would think, would be very important towards that goal. So how do you see that playing out as you go towards the confirmation of the plan? What are some of the other concerns and issues?
I think you're right. I think that, most of the time, the reason these cases work out okay for sureties is just what you said. The need for surety credit that existed before will continue after. And in some cases, it just flows right through. And, in all honesty, nobody pays too much attention to it, particularly if it's not a huge amount of surety credit. And life just goes on. Business goes on as usual. And, it works out because everybody has the same interests. Even in the most sophisticated cases, once the parties understand what needs to be done, it almost always does get approved and get, documented the way it needs to. I think the biggest danger, and blessedly it's a little more rare, is when things don't go right, when the company can't reorganize, right, when it's not going to go on. And it sets off a situation where all of the creditors are scrambling for a small amount of assets. And at that point, the surety is not an important business tool anymore. They are just another creditor. And, that's the situations where, frankly, the surety is going to have a loss, and there, may not be a lot that it can do about it at that point. The good news is that while most Chapter 11s fail, most large commercial Chapter 11s that the sureties are involved with, and this sounds strange, actually do reorganize in some form. The sureties tend to support industries that have the supply needed goods and services. And so consequently, there's always a value component there that somebody wants to make sure survives and goes on into the future to protect whatever it is, the debt repayment, the investment. And blessedly, we're very contrary to the overall bankruptcy trend, which is most reorganizations fail. Most of the ones that I'm involved with surety clients, have a very high probability of, moving forward and working out okay. My concern is that as we hit a big bump here in the near-term future and a lot of these collateral businesses are sucked in, that it's going to be less surety credited issue, but I think the rates of failure are going to be significantly larger than I've seen in, say, the last 10 to 15 years.
Wow, I'd love to see the data on that. I mean, that's another selling point for surety relationships.
Yeah.
To know that kind of having that established relationship and interdependence can, even in a tough time like a reorganization, can get them through.
Yeah.
Any final thoughts that you have in terms of advising a company who is thinking about this and their surety, what they should be thinking of right now in this during this crisis?
Well, it's always a tension, as I know you both know. From a claims perspective, from the side I'm on of the bankruptcy, you never want to ask those people how the relationship should be structured, or it would be difficult to write any bond, particularly in a competitive environment, right? I do think it's a time to think about unsecured commercial accounts. Surety credit is staggeringly valuable to the people that need it and use it. And it's not an over-exaggeration, it's oversimplification to say, and I tell bankruptcy judges this all the time, if you don't have this, and you fill in the blank, this permit bond, this custom bond, this whatever, this workers' comp self-insurance bond, this company is done tomorrow. And, yet they treat it as if it's just some, automobile insurance policy they paid the premium on 6 months ago, and it's not. And while there's some competition in the marketplace and somebody else is interested in providing the same surety credit, possibly with less security, there are, of course, limitations, but the surety credit is far more valuable than it costs, or in the security that sometimes the sureties are asking for. So I do think it's a time to consider some moves, in the collateral position, and have a closer relationship with some of the accounts, so that if there are stresses, if they have to start planning, they remember that they not only have a surety, but they know they've talked to them with their agent, and they involve the surety early, because there's so much more you can do if you're not playing catch up.
Wow, valuable perspectives.
Yeah. Thanks so much, Chad. It was great getting to chat with you today. So much interesting and valuable information about how to handle the commercial surety account bankruptcies that we're seeing so many more of now. It was great talking to you, and we'll have to have you back on again sometime soon.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.